with standard of care, the big issue is that a design professional is not expected to be perfect. We don't warrant and guarantee perfection or perfect results or perfect services. The courts around the country hold us to a generally accepted standard of care that would be the equivalent of what our colleagues would do on similar projects, similar circumstances, similar time and place. So if you and I had no contract at all, if we just simply agreed, I said, hey, Zach, I'm going to provide professional services for you, and we just do it on a handshake deal, which is fine. We can do a handshake deal. We say, gee, we shouldn't do that. We should always have a written contract. But I got to tell you, sometimes it's better not to have a written contract. I see contracts that have these outrageous standards of care that are not insurable. But if we just had a verbal contract, the court would say, then what comes along with that verbal contract is a normal standard of care. It just happens just by the common law. And so the court will say, well, you had no written contract, you had a verbal contract, the standard of care, it means you just don't be negligent. So as long as you provided your services in a non-negligent manner, then Zach can't sue you. And so that's what we want, is that standard of care. So when we look at some of the issues that we see coming out of these standard of care, and I threw up a couple clauses here just to make our conversation easier to follow, and then if anybody ever wants to go back and look at some of these examples, they can do that. You can save these slides that Zach is going to share with you as sort of a permanent resource. So this one that I put up here says that the designer is going to do its services consistent with the highest standard of care recognized by a nationally recognized consulting firm. And that just creates problems, because we're no longer being judged by the generally accepted standard of care of people in our neighborhood. I like to say I'm over in Virginia and I do services all over the whole country. But if I'm going to be designing something in Virginia, I want the standard of care for whatever I'm designing in Virginia to apply to me, and not the standard that might apply to me if I was in San Francisco or LA and I had to design a bridge to earthquake standards. So I know if I use those earthquake standards to design my little bridge, my little footbridge here in my backyard in McLean, Virginia, that bridge would probably stand up for the next 100 years. But I don't need to do that. I just need to make the standard of care for a footbridge that'll last, 40 years. So we don't want to be judged by this highest standard, because when we go in to defend you when a claim comes in, we want to be able to use an expert witness that says, well, here was what the standard of care is, and we met that standard. And the plaintiff has to have an expert witness to say, well, the standard of care was X, and they failed to meet X, and they caused this damage. But if they come in with this highest standard, well, what is the highest standard? I don't even know what it is. I won't know it until I see it in court. And they bring in the Donald Trump gold-plated standard, and they go, wow, here's the way I would have done it if I wanted a gold-plated toilet in the Trump Tower. I'm like, but I didn't want a gold-plated Trump Tower. You were only paying me, $10,000, and that only included a $150 commode, right? So you're being judged by this ridiculous standard. And what I find interesting is, so often the owners that put in these highest standards of care and these really uninsurable clauses, they're also the most difficult to deal with. They're the very ones you want to have protection of good contract language, because they're the first ones that want to sue you. Like I would not be surprised to see this kind of clause in a contract with an attorney who is having you design a house for him. Man, you're designing a house, that's already trouble. You're designing it for an attorney, that's twice the trouble. And then they stick you with this clause, you're dead. So anyway, you get my point.
Different, words there sub that in, and it alters the standard of care, right?
That's right. Those are other good words that you put in there. We do see those. Absolutely. Yeah. Well, if you look, I'm going to compare it now to the AIA. And so one of the things I like to do when reviewing contracts is to go to the American Institute of Architects, AIA B101 contract for design firms. And they call it for architects, but engineers can use it. Anybody can use it, and you may be an engineer working for an architect, and you're going to see this contract. And so this clause is, I would call this the ideal standard of care. When we started our conversation, we said, the court's going to impose the generally accepted standard of care in the absence of a contract. But here, the AIA has picked up that language and put it right into their contract form. And so if you ever get confused about, well, what wording should I use for my standard of care, this would be the wording. Just borrow the AIA wording. Zach, one of the interesting things is I review, people will say, can you please read my standard form contract? I've got a standard form template that my firm created. And I'm surprised sometimes when I look at those standard forms that they don't have a standard of care in them. And the first thing I'd want to do in my standard form contract is put a standard of care like this one. And then I might even add another sentence to this saying, and by the way, we're not going to grant you any warranties or guarantees.
That's another really important point.
So you see, you see, I picked that up on this slide. It's kind of funny because you could have a really nice standard of care clause like that one that we just showed from AIA, and then elsewhere in the contract, you start finding these clients that use words like the architect shall ensure that this or that happens, shall assure that it complies with all rules, regulations, and codes. It shall, what else? Shall comply instead of shall express standard, just shall comply with this and that. And if you don't comply and I receive any damages, then you're going to indemnify me. So those things all start to sound like warranties, even though none of them says this is a warranty. I look at them like, it sure looks like a warranty. Or another one would be time of the essence clause, where it says you're going to, all services are of the time of the essence. And that term gets used in construction contracts all the time as something a contractor does. You commit to a schedule. If you don't meet that schedule, then you're going to owe liquidated damages. But we as design firms should not be agreeing to owe liquidated damages for missing a schedule. We may have to miss the schedule for any number of reasons. It may be standard of care required longer to evaluate something than we anticipated. It could be that the government was slower in reviewing a request for a right-of-way or an easement or an approval of something that we needed before we could move to the next step. So all these things should basically excuse our timeliness. So whenever I see that type of a term, shall meet the schedule, is subject to the time of the essence, then I would actually want to add this type of phrase again, that this doesn't constitute a warranty or guarantee. And so what I like to do is if I'm reading a contract, and some of these contracts can be really long and fine print, and you go, well, I think I'm pretty good at catching things in a contract. But on the other hand, you guys that are having Zach and me review contracts, you're not paying us to be your attorneys. So I am an attorney, but I have a big disclaimer that I put in my reviews. I think I have it at the end of the slide set here today that says, hey, I'm not giving you a legal review. I'm not your attorney. I'm not practicing law for you. I'm just giving you some general risk management ideas and suggestions. So you need to go get your own attorney to review this contract. So we're looking to provide our turnaround for these contract reviews. We try to get them done in 24 to 48 hours from the time they get sent to us. And we try to spend an hour or less doing our review. I mean, we want to knock these things out. I have a group of 6 attorneys in my group, and we've been doing this type of work for many, many years. And we know what we're looking for. But it's hard. In 1 hour, we could very easily miss some hidden warranty or guarantee. So if we add that little clause right there, it really protects all of us. Because even if we miss something, because we're going to try to strike out, when we see those words somewhere, we're going to strike them out. But this little catch-all is our, belt and suspenders. It means if I failed to knock it out, I still have this clause saying, well, we didn't intend to give you a warranty or guarantee anywhere in this contract.
Right.
It's very powerful.
That's a really important point to make, Kent, which is, we're talking about the standard of care for design professionals, but when you and I are reviewing contracts, we have a standard of care, right? And that standard of care does not include perfection. And, I think sometimes that point is missed by our clients, which is when your client sends you a contract and it's a War and Peace. It's a 100, 200 pager, and you hand that over and say, hey, can you take a review? I mean, you could spend a week going through that thing with a fine-tooth comb and find a lot of things that need to be changed. And then we get into the whole of the other argument of whether or not they're actually going to be changed, right? Do we have the negotiation power to make that happen? So, our standard of care, we're really keeping this to, somewhere between what I'd say 6 to 12 clauses. Does that sound right? I mean, some kind of really important, I mean, maybe not even that many, depending.
Yeah, that's probably right, though. It's like, the first thing I have to do when I bring in a new construction attorney to work with me is try to get them to quit looking at the contract like they're a construction lawyer for a client. And I'm like, we can't nitpick everything in the contract. We're going for the big fruit here, the low-hanging fruit.
Right. That's, where can we make the biggest impact? Right.
Right.
So that's good. And then my other comment where there was the warranties and guarantees, that code compliance, right? If there's one thing we see over and over again, and you hit the nail on the head, it is, warranting or guaranteeing that you are in compliance with any and all codes, right? We see that sometimes, and that's unreasonable. And then this schedule, we understand scheduling is so important, but there's just no way for a design professional to guarantee that a job will be done by a certain day, right? It's just not reasonable. There's so many things out of your control.
Just another example. I'm not going to go into this. We've already kind of beat this one up, but just some good example language that you can use to, what I'm saying here is, you might find a client refuses to remove a term like highest standard. They might refuse to remove a term like time of the essence. And that actually happened to me a week ago. The owner said, no, we've got to have time of the essence. And they just wouldn't get rid of that wording. Or another owner has insisted on highest standard. But when I went back and I said, well, that's uninsurable. And you as a project owner, you're not going to get anything, you're not going to get blood out of a turnip here. We're a design firm. All we have, our only assets are we the people. We don't have yellow equipment. We don't have big bank accounts. We have nothing you can attach. We are nothing other than our individuals. So the only thing that's going to help the owner is the insurance. And so if you create contract clauses that make it possible for an insurance carrier to say, that's not covered, we're going to just not even respond to that. We're not going to defend it. We're not going to do anything with that claim. That doesn't do the owner any good. So what we'll go back to, and like on the time of the essence clause last week, I said, so we don't want to have that uninsurable liability. How about if we say time is of the essence, but this doesn't create a warranty or guarantee? And the owner's attorney said, well, yeah, that's reasonable. And that's exactly our compromise. So, all right, fine. They get to keep their language and we get to put our disclaimer of warranty. Everybody leaves happy.
Gotcha. I love that. That's such an important point. If something in the contract is creating an uninsurable exposure, everybody loses. Right? The client, our clients, the design professional, aren't going to be able to pay it because it's not insured. Like you said, there's not assets. There's not hundreds of thousands or millions of dollars sitting in a bank account somewhere that is for all of these uninsurable clauses that people put in contracts. And the client of our client, the project owner or whoever it is basically not going to be indemnified, right? So they're not going to be made whole. And so nobody benefits from signing language like this.
One of the things I like to do when I talk about contracts is I look to case law, and I just enjoy reading cases involving design professionals. And I do a monthly or a bi-monthly newsletter that's available on my website, and all the way back to 99 when I first started writing these newsletters, they're all still there, and they're keyword searchable. So you can go to ConstructionRisk.com and subscribe to the newsletter. It's free. And so this case and others that I put in here, I have written entire articles about in my newsletter. And I pick cases that I think we can learn from. So this particular one, I thought really had some interesting discussion of a particular word or two that I wanted to make sure we talk about. So in this one, what we had was a condo association. files a lawsuit against a designer who had designed the condo complex. And they allege that this designer breached the implied warranty of habitability because air and water infiltrated into the building as a result of actually what I think it was construction defects, but they're alleging, well, it was a design defect that caused this to happen. And the court threw the case out. It didn't let it go to a jury. The court said, no. The designer is not subject to liability on this theory. And the court cited the principle that the architect doesn't warrant or guarantee perfection. So love it. So it's a great decision that, if somebody says to you, well, who says they don't warrant guarantee or guarantee? Well, this case does. And this case quotes a bunch of other cases that go back many, many years for this principle. Now, why I like this is the condo association alleged that the design firm failed to perform its work in a workmanlike manner. And that word workman really is bothersome, or workmanlike. And whenever I see that in a design contract, I strike it out because I'm like, we're not a workman. A workman's a guy who's holding that little sign on the street, when they are doing construction. You got to come up on the motorcycle and wait until they turn it around. He's a workman. It's not a skilled labor that he's providing. It's not something that required, technical skill and knowledge. So the court cited Black's Law Dictionary, which is the authority on, legal terms. And the court says the term workman doesn't include professional persons like design firms. And there's a lesson to be learned in your contract language here, is that whenever you see words like good and workmanlike, think about what the court's saying here. The court's saying, well, a designer isn't a workman. He's not subject to a workmanlike skill. But if you were to actually put into your contract the actual words, they will perform in a good and workmanlike manner, well, the court could look at that and say, you agreed to something beyond your professional standard. That's what you did when you said good and workmanlike. You're going to be judged like you were a worker instead of a professional. So even though that clause seems innocuous, it's not. You need to strike it out. And whenever I see it, I just say, we're going to perform consistent with the standard of care. So somewhere at the very beginning of the contract, the first time I see a description of the standard of care, I will put I'll create a parenthetical and I'll say hereinafter, quote, standard of care, close quote. So now I can just keep going back and referring to that standard of care that was defined up on page 1 or 2 of the contract. So like Zach was saying, you see code compliance. Well, now we can say, well, we're going to comply with the standard of care. We're going to exercise the standard of care to comply with the codes. Well, the standard of care is what we defined up at the beginning.
That makes so much sense. Just we're going to establish this definition early, and then everything that we're going through, after that is going to refer back to said definition. Very, very simple but effective way to make that work. So love that.
Very good. So I'm going to put up another case here, so we can just chat about it. And in this one, it's actually a home builder, a developer, Pulte Homes. And what they did was they sued a design firm that had performed engineering and testing services for them. And they had to resolve certain defects through arbitration proceedings. And I guess Pulte must have paid the homeowners damages as a result of that arbitration. So then they turned around through litigation and they sued the designer to recover what they paid to the individual homeowners. And their theory of recovery was that the designer had given express warranties and guarantees, or express or implied warranties. And Pulte alleged, you can see the quote here, that they expressly or impliedly warranted to Pulte that the work would be performed in a workmanlike manner. See the word workmanlike in there.
Yep.
So, and then they make it even worse. that it's going to be merchantable and fit for their intended or specific use. Well, those words, merchantable and fit, that's uniform commercial code type warranty wording that's used for suppliers of materials or equipment or goods. It has no place in a design contract. So shame on the designer that would have allowed this kind of wording to be in their contract. One would hope that they did not have their wise insurance broker or their construction attorney or risk manager review this. Hopefully, we never got a chance to see it and comment on it. But you can see that the court concludes that by including this type of language, that this did indeed, arguably at least, create an express warranty. So here they are stuck with a warranty because of this unfortunate wording.
Gotcha. So the court ruled in favor that it was an express warranty.
That's correct.